information they had gathered, and after they presented their PowerPoint presentation to the prosecutors. Against that truth of how we got here, I want to address the privilege log that we suggested would be an efficient way for this court to tackle this bear. The question that this begets is, how in the world are we to ascertain who hit the ground running interview or what they collected if they're not willing to tell us? Well, the very prudent way that is often employed in civil cases is a privilege log. Could not be a more simple way to pare this down, give us a target to shoot at, and give His Honor an idea of why this might be privileged and why this might not be in a very efficient manner. That's why we made the suggestion. I reached out to these very fine lawyers a month or so ago and asked them what they thought about a privilege log. I didn't hear back from them, but they've made their position clear in their papers. As I was getting packed up to come out here, one of my boys was helping me, and he asked me what this hearing was about, and I told him. And he saw my binder here, and he said, "Can I read some of it?" Absolutely. So he started reading the papers of Hit the Ground Running, and he asked me a few questions. What does materiality mean? Did my best to explain it to a 12-year-old. Well, what about relevance? Again, I tried to. He went back to the brief and read a little bit more, and he posed a question that I think encapsulates what we're asking about better than anybody. He said, "Dad, how can you tell if the information is relevant if they won't tell you what they have?" Simple enough for a 12-year-old to get it. These are very, very capable First Amendment lawyers, and they have done a yeoman's job of preventing the disclosure of information that Hit the Ground Running does not want to share. Now, that being said, they know their opposition to a privilege log has no legal precedence. Neither does our position asking the court to. It lies within this court's very sound discretion in looking at this and saying, look, fundamental fairness here. How can we go about this and make sure that we don't compromise Mr. Dersh's right to a fair trial? The next thing I thought of was this kind of evolving argument that we've heard from the Hit the Ground Running producers. Through Mr. Lewin, who I trust always represents things accurately to me, we were told there were about 50 recorded interviews. Those recorded interviews were imaged by the FBI, turned over to the people turned the same over to us. We later learned that there were actually 54 recorded interviews. We were told we had them all. But as this story evolves, I learned from Mr. Jarecki himself that there are at least 3 more interviews out there, recorded interviews. And it's a very important distinction here. I keep saying recorded interviews for a reason. But Mr. Jarecki wants us to believe these 3 recorded interviews that we don't have are of no moment. In fact, his own words, Your Honor, quoting Mr. Jarecki, "We have produced the overwhelming majority of the recorded interviews conducted for purposes of the jinx." I get very nervous when I read that, Your Honor. There are a lot of qualifiers in there. Recorded interviews for purposes of the jinx. There are far too many qualifiers in that little sentence to trust it. Mr. Jarecki goes on to explain the remaining recorded interviews are comparatively peripheral. I had to ask my son what comparatively peripheral meant because it was a bit confounding. But these quotes really do reflect the problem, Your Honor. The wordsmithing alone makes a lawyer in charge of ensuring Mr. Durst gets the fairest trial he can get quite nervous. It makes me wonder, what are these very well-crafted words designed to hide? And let's go back to my arguments in the agency context, because they come to bear right here. And the part of it that comes to bear is the part that the court accepted is we have, without question, established Hit the Ground Running's motive in the production of this television series. given their motive was clearly, on the one hand, to promote their cinematic piece, they saw it as incumbent upon them to further that motive with the second motive of getting Mr. Durst charged. I quoted you time and time again, Mr. Jarecki, Mr. Smerling's own words that established beyond peradventure, during that project they decided they needed to get Mr. Durst charged with murder. Therefore, given that motive, their credibility here has to be put in the proper light. They continue to represent themselves as journalists.
Your Honor, I apologize. I don't mean to interrupt you, Chip. There's a witness who was in here that I meant to advise the court of. Doug Oliver, Mr. Durst has talked about calling Mr. Oliver as a witness. He is in court right now. We're going to ask that he be excluded and asked to step out. I made the request to him prior to the court taking the bench. He is still in the courtroom. I was going to ask the court, Your Honor, the defense has indicated that he is going to be a witness for them. It is possible we are going to be calling him as a witness, and it's therefore inappropriate for him to be listening to arguments regarding either this issue or handwriting, etc.
I didn't know the rule applied to a non-evidentiary hearing. It said public.
Right. So ordinarily, the idea is to prevent witnesses from hearing each other's testimony. That's been it can be extended, particularly when you're arguing about that particular witness's testimony, and there might be some hint to the witness from the argument that the witness ought to shade his testimony in one way or another. For example, in a suppression motion. That being said, there is that right to a public trial. That's where the tension is, and also, of course, you have the right to cross-examine that witness on his presence at this very hearing, to the extent, and that may be effective to reduce the credibility of testimony under the circumstances. Perhaps, though, because it's controversial, this witness would choose to step out. I don't know. You've asked him, and he has not.
Mr. Oliver's seated in the white with the ascot, Your Honor.
I see. Yes. All right. The gentleman's there in the front row. Well, overruled. You may continue.
Thank you, Your Honor. Sloan took 3 minutes of my time to make that airplane. I'm going to hold that against you.
You'll make it. I don't know if you'll hear the ruling.
That's fine. Mr. Chesnoff, Ms. Bain, and Mr. Ray will, and our very capable court reporter, I will read. The journalist, Merriam-Webster's defined a journalist as a person who collects, writes, distributes news or other current events to the public. What do journalists not do? Journalists do not interview folks, edit their material, piece it together to produce their motive, tease the suspenseful conclusion of their work for their dramatic series. Journalists just report the facts. They do not manipulate the facts and try to pass them off as the truth. And then embark on a national-wide media blitz of self-flagellation. Their victory lap at the conclusion of the Jinx and Mr. Durst's arrest was halted only because of a very wise suggestion of one law enforcement member who called Mr. Jarecki and suggested, hey, you might want to shut up. You're now the primary witness in a murder case when the man you got charged with murder faces the death penalty. Your Honor should exercise the proper discretion in this area. You have all the discretion in the world as both hit the ground running and we have cited for you. Relative to the refrain in the hit the ground running papers about the burdensome, costly inconvenience to the producers. I'm not going to shed many tears for the producers, Your Honor. They made millions off of getting Mr. Durst charged with this murder case. Incumbent upon that is the obligations that our Constitution is going to put truthful and credible information before the jury. Their goal was not further cinematic suspense, make this, quote, a lot more damning than it really is when viewed as it actually was said. This motive that flows from the gathering of information, the making of their movie, to getting Mr. Durst charged, didn't die when Mr. Durst got arrested. It's the same motive they have in resisting the the discovery prior to trial. All the articles do, Your Honor, is they illustrate the fact that there is, in fact, debate, controversy over the propriety of the editing we've talked so much about. We're not offering for the truth of the matter asserted, whether it was proper or improper. We're not journalists. I'm not a film critic. Good for Mr. Jarecki. But what this court is called upon now in ensuring Mr. Durst has a fair trial is looking at the fact that they did have a motive for their actions. Their motive makes it suspect as to why they have not produced certain things, what might be out there, and this is why the court should take judicial notice of that. I will say this lastly on judicial notice. Unless they finally want to honestly admit that the editing was misleading, as everyone else has concluded, as the people have told this court, they wouldn't do that because that is not the truth of Mr. Durst's statements in that instance. Then the court can properly take judicial notice of this to establish for the court, for our purpose of motive, not for the truth of the matter asserted. Last part before I conclude, Your Honor. Having been tasked with this all things jinx in this aspect of the case, I have come to know quite a bit about the producer's history. And frankly, there is a very concerning pattern here of manipulation for the benefit of cinematic success. In a previous project, Capturing the Freedmans, I don't know how familiar Your Honor is with this factual matrix, but Mr. Jarecki produced a picture about two freedmans. There were two men who were wrongfully framed by law enforcement and forced into pleading guilty to crimes they did not commit. That was his premise. That was what his movie was about. That was the conclusion. However, less than a year after the film's release, a plethora of inculpatory evidence surfaced. It became apparent that Mr. Jarecki had intentionally omitted an interview of Jesse Friedman, wherein he admitted his guilt, detailed his involvement in the abuse of children with his father's assistance, over 17 children ages 9 to 11. He also intentionally admitted the existence of a third co-defendant who had admitted guilt and went to prison for his involvement in the crime. Law enforcement and the victims of the Friedman's offenses were up in arms. And consistently, they all wondered, why did Mr. Jarecki twist the truth? Why did he ignore things that he knew were contrary to his conclusion? The filmmaking methodology present with the producers of the Jinx demands that we scrutinize as we have and continue to scrutinize to ensure there is not information out there. I fear, Your Honor, the reason Mr. Jarecki uses recorded interviews repeatedly when he refers to any of this is, what about the interviews they didn't record? They didn't record them because they didn't fit their theory. But they have notes, they have conversations that are memorialized, they have evidence of these other interviews that could be either exculpatory or produce impeaching information about other interviews. We can't take that chance. And here's why, Your Honor. If this court allows hit the ground running to suppress the requested information that we need to properly defend Mr. Durst, we're going to start down a very perilous path. And it's my prediction it goes something like this. We spend weeks, if not months, picking a jury. We get into our second month of testimony. The people call one or more of the producers, as they said they will. Under vigorous and proper cross-examination, we all learn that indeed there was other material out there that they didn't disclose. And in fact, this other material does bear on the innocence of Mr. Durst. It does impeach other witnesses that the people have called. It should have been provided a long time ago so the defense can make effective use under the Sixth Amendment's guarantee that Mr. Durst will receive effective assistance of counsel. Then the court gets to declare a mistrial or grant a lengthy continuance to ensure the trial remains fair, as this court will insist. The jurors that have sacrificed so much of their lives have done so for naught. The millions in taxpayer dollars that the good folks of California have put forth have been wasted. Having gotten a great sense of this court and this court's rectitude, I know this court's way too wise to go down that perilous path. We ask your honor simply to do one thing. Do the right thing. Make sure they give us everything that they should. We suggest that the most efficient way to do that is to grant a privilege log. Let us work with hit the ground running parties. They will tell you I'm very communicative. I've answered every call, every email, make myself available whenever they need to talk. Perhaps we can narrow this privilege log, narrow the universe so the judge knows what we're fighting about and so that we have a fair target. We shouldn't allow this third party, and they're not a true third party in the sense of many of the cases that His Honor studied. This is far different kettle of fish. They are the reason we're here. It is their work, is the only reason we're here. They can't be allowed to force us through a trial of subterfuge or cherry picking what we'll see and what we won't see. They cannot use the journalist privilege, the journalist shield, as both a sword as they did in their cinematic adventure, and then now come in here when Mr. Durst faces his life, a death penalty case, and try to use that same journalistic privilege as a shield. That's just not fundamentally fair, Your Honor. We ask you to grant us all the relief this court believes is we are entitled to under the law and in this court's sound discretion. Thank you, Your Honor.
Thank you, Mr. Lewis. Before we take our lunch break, we do break at 12 o'clock for various reasons. In my haste to hear Mr. Lewis's argument, I neglected to ask for the appearances of counsel for the real party interest. Will you state your name for the record?
Yes, of course. I'm Linda Steinman of Davis Wright Tremaine. I'm here to represent Hit the Ground Running, and this is my colleague Dan Laidman of Davis Wright Tremaine.
Thank you. And what have you done with Mr. Kaufman? All right. You can answer that question at 1:30 when we return, but we'll be in recess.
Thank you. Rest assured he's fine. Mr. Confounder is very well.
Thank you.
Don't do that. He looks like he's just
The mic is on over here. Kathy, you said the mic is on.
I just turned it on.
Yeah, just so those on.
It's a secret until the judge says it.
Yes.
Yes.
She said she'll speak to you.
Cool.
Private 81.
Hello.
Are you going to give me a copy of Dorothy's affidavit now?
Yes, you can read it now, but Washington won't let you take it back to the jail. Well, we can send a copy to the jail, but you can read it now if you like.
Okay, but now you do?
What was?
Why not just
Okay.
give it to me and I'll take it now?
Yeah, you're gonna have to use the list of all the people you have to contact. You said send it through the LAS for the audio request. So I have that.
Just
I have to
right.
give you a copy. It's in the DHS.
Rain season come to order, Department 81.
Seated.
You can make a view if you know how. But I don't know how to make it.
Good afternoon, everyone, and Chief Lewis, and that's why
I did, but I've explained all back home. I'm on a 318, so I have 30 minutes or so. Enjoy your Honor's presence.
oh, well, you know, there's other priorities you have. But, all right.
Thank you for asking.
All right, we're back in session. Mr. Durst is here with his lawyers, Mr. Ray, Mr. Chestnut, Mr. Bain, Lewis, and for the real party interest hit the ground running and named witnesses. We have Ms. Steinman, and you may address the court.
Yes, good afternoon, Your Honor. In defense counsel's presentation, he made no mention of the cases and the legal standard. Sanchez and Ramos, two of the leading cases, were also capital cases, and Vasco was a murder trial. All of these cases made very clear that there is a very high standard to be met when seeking materials from a journalist. The defendant has the burden to show a reasonable possibility that the specific information sought will materially assist the defense. As the appeals court said in Vasco, the defendant must show that the substance and purpose of the evidence sought will assist them materially. In all of these cases, as in the vast majority of the appeals court cases, the courts found that the defendant did not meet this very high standard, that their theory was speculative, and the evidence sought was cumulative. Here, the defense has stood before you and said there are some notes from people that hit the ground running interview. They don't identify who those interviews were of. They don't identify why they might be relevant. They don't identify what purpose they might be relevant to. All they say is that there are notes of some unknown interviews that, quote, could be exculpatory. Respectfully, Your Honor, this gets an F under the prevailing test. This is exactly what the cases say is insufficient. The identity of sources interviewed by journalists are squarely protected by the Shield Law. That's always been one of the things that is sensitive in a journalist's investigation. And here the burden has not been met. We started, Your Honor, when the defense first served a blunderbuss request for practically every piece of paper that hit the ground running created over a 5-year period of time. You and I would have drowned in that amount of material.
I was amused when Mr. Kaufman used the term blunderbuss. Out here on the West Coast, a shotgun is the more fancy metaphor. But a blunderbuss, I suppose, is...
It's very colorful.
Equally apt. You may proceed.
They seem to have abandoned that along the way, and in their papers, they rightfully, frankly, focused on the only 2 pieces of evidence from Hit the Ground Running that are centrally relevant. The interview transcripts of Mr. Durst and the March 1999 letter with the misspelling of Beverly Hills. In our papers, we established that we have turned over all of the important documents about those 2 items of evidence. We have long ago, 5 years ago, provided the complete unedited audio and video from the Durst interviews. In what I think is unprecedented, the journalists even allowed the FBI to come to the Hit the Ground Running offices and to make a forensic copy of the audio and video. The defense was provided with a copy of that. The people hired a tech expert who reviewed those tapes and determined that there was absolutely no alteration, editing, anything, that those were the original authentic tapes. Second, the defense in their papers focused on the March 1999 letter, and we established that first, we don't frankly know that much about it. It was discovered by Sareb Kaufman, who will be the principal witness about that letter, and that all we can testify to is after it was given to us and put in the safe deposit box, and our declarations describe that, and our witnesses will be happy to testify to that. So it was clear that those two items of evidence, which are truly what my clients can contribute to this trial, do not provide a reason to search through every email they wrote for over a 5-year period. The defense has now come in, they seem to have abandoned that, and they appeared today to say that what actually they want is the notes from some unknown, unnamed, unrecorded interviews, or at least a privilege log of that. They don't identify who these interviews were of, or why they want them, or what their significance is. As I said, Hit the Ground Running's role in this case will be rather limited. Mostly it will be to authenticate these, the tapes of Mr. Durst, his own words, and to provide the chain of custody information about the Sareb Kaufman finding of the letter. They will not be testifying about some unknown, unrecorded interviews. The prosecution has already provided the defense with the evidence that they will be using in this case. It doesn't include any unknown, unnamed, unrecorded interviews. The fact that the prosecution and the defense don't have something mean it's not going to be part of the case. So these unknown, unnamed interviews are just a red herring. It was also interesting and important that the defense has conceded that the jinx is not going to be introduced into evidence in this case. The jinx is a TV show. This is a court of law, and what will be admissible here is the unedited, complete bathroom confession and the other unedited tapes of Mr. Durst talking. His own words will be what's evidence. The jinx is irrelevant. I obviously strongly dispute the defense's attempts to malign my clients, both the jinx and the capturing the Freedmen. Freedmen's were fine works. They received many awards, but I'm not going to waste time doing that because it's irrelevant. Those films will not be shown to the jury. They will not be eating popcorn and binge watching them. They will be focused on the evidence. I'd like to talk about the cases because really that's what's important here. Delaney provides that we are balancing two constitutional rights here. One is, of course, the right to fair trial, which is very important, but the second is the California state constitutional right set forth in the Shield Law. Delaney teaches us how we balance those two rights and says that the defendant has the burden and must show a reasonable possibility that the information sought will materially assist the defense. Even if that threshold showing is met, the defense has to go further and show that the information sought is not especially sensitive, that the Shield Law policy wouldn't be thwarted, that they really, really need the information, and that there are no alternative sources. Here, the defense doesn't even meet the basic good cause standard for any third party, but certainly doesn't meet the requirements under the Shield Law. Sanchez, Ramos, and Vasco all show how difficult it is to meet the showing. These were all instances in which a reporter had gotten a confession from the criminal defendant. They were all cases in which the defense sought something much more narrow than at stake here. They sought either the notes for the interview, the specific interview of the criminal defendant, or the tape. Nonetheless, in all three cases, the courts found that the reporter, that the defense did not meet the standard. Each of them articulated really quite precisely why they needed the information, much more so than in this case. For example, one of the criminal defendants said, look, this article quotes me saying that I admitted to a triple murder, but it's a paraphrase. It's not an exact quote. And I would like to see the notes or the tape, because they'll show exactly what I said. And that will be very important to my case. Court said no, that's not sufficiently, that's too speculative. Another case, the criminal defendant said, if the whole tape or notes are produced, they'll show that I was coerced into the interview, that I was misled into this interview. You'd think that would be pretty specific. The court, again, said no, too speculative. Another case, the criminal defendant said, there was undoubtedly some useful information to my defense that was left out of the article. I want to find out what else was said during the interview that would have been left out, because that will show, put the article in a different light. Again, the court rejected that, found that was too speculative. The Sanchez case is frankly the most important one. In Sanchez, the reporter had done 5 interviews with the criminal defendant. The criminal defendant had said he had committed the triple murders, that he had killed the victims for the Social Security checks. He reenacted the crime for the reporter, and he also had other instances in which he said that he was present and involved, but he wasn't the one who actually did the killing. He argued that he needed the tape of the interview because he wanted to know the actual words rather than because the reporter had only paraphrased, and he wanted to show the tapes to show that he was sort of contradicting himself, that he was inconsistent, that he was sort of confused. That he, in general, wanted the tapes because he wanted to impeach the reporter's testimony based on the printed article. The California Supreme Court said this does not meet the Delaney test. He never shows how the information sought would materially assist his defense. His argument consists of nothing more than self-serving statements, and that this is too speculative. In short, under this standard, the defense falls woefully short. These unnamed interviews will simply not be a part of the case, and so they can't be materially relevant. And there's no articulation of why or how they will materially advance the defense's case. In terms of a privilege log specifically, as defense counsel has admitted, there are no cases establishing that in a criminal case that a third party should have to produce a privilege log. As I said earlier, even listing the people that we interviewed is a significant intrusion on a journalist's independence. And there is no reason to justify such a fishing expedition here when those interviews will not be part of this trial. In sum, Your Honor, my clients have bent over backwards to Mr. Durst to produce far more material than most journalists ever produce. Before this case started, they went to the LA District Attorney's Office and they provided the complete interviews of Mr. Durst and Mr. Kaufman. It was not the television show that led to Mr. Durst's arrest. It was the evidence that they provided to the District Attorney's Office that led to the arrest. But in addition to providing those, as I said, they let the FBI come to their office. Absolutely unprecedented for journalists, but they wanted to allow both the people and Mr. Durst to be able to have 100% confidence that the tapes were authentic and hadn't been tampered with. They were then subpoenaed by the people. The people were the ones who listed the 54 interviews that they wanted produced in this case. It's very unusual for journalists to do that, but they turned them all over, again, in an attempt to be fair. The defense issued their broad subpoena. We produced 1,800 pages in response to that, consisting of all of the communications between Hit the Ground Running and the LADA's office prior to the arrest. So at extraordinary expense and frankly time, they have produced a substantial amount of material, but enough is enough, Your Honor. And the information sought at this point is just a fishing expedition. Whether you call it a shotgun or a blunderbuss or whatever metaphor you use, they have not met the standard, and it's just guesswork. Thank you, Your Honor. Do you have any questions?
Not substantive. I'm just now trying to think of a better metaphor than fishing expedition. We have these sporting...
Trolling.
Trolling. Okay, there you go.
I realized at one point I was thinking about an ocean of
You're not supposed to
documents.
help them, Chip.
Yeah, they're not to be helpful.
I read your moving papers quite carefully, so thank you. I have no questions.
No, thank you very much, Your Honor.
All right. The threshold issue, before we get to the threshold issue, the evidentiary issue is judicial notice. So as far as judicial notice, the facts sought to be proved must be relevant before I take judicial notice of evidence. And so here we have a request by the defense to judicially notice various news articles and other documents. And they largely consist of criticism of the editing and other aspects of the jinx, which are not relevant because they're not evidence against Mr. Durst. Indeed, the original evidence is what is admissible. I'll point also that Mr. Jarecki is not on trial. It is Mr. Durst who is on trial here. The judicially noticed material, if it is relevant, may prove the fact of a publication, if that matters, but not the truth of the published facts. So the court will decline to take judicial notice of the publications. If the publication itself is relevant, the court will consider that for such limited purpose, but that's not been shown. Now, as to the nature of the immunity here that we're discussing, and despite the defense criticism of hit the ground running, no one can reasonably question that they do meet the very broad definition of journalists. Even if the defense claims they're bad journalists, still journalists they are, and they're protected by the First Amendment and statutory immunities. So they may be compelled to give up their unpublished work only to protect the right to a fair trial. And that doesn't mean if there is a trial, they give it up. Under Delaney, there still must be a plausible basis for discovery, and then the court balance the interests. Mr. Lewis asked me in a very, or described a vividly described a scenario wherein the trial would be interrupted by some unpublished material coming to light, which might raise reasonable doubt of guilt. I'd have to give a continuance for investigation of that. But of course, one can always fantasize such a situation or reason that anything is possible, and because anything is possible, there ought to be discovery of the possibility. But it's hardly a basis to compel a journalist to give up protected materials. So as far as the idea that some material might come to light which might fundamentally change the nature of the trial or affect the accusations, well, what reason do I have to believe this is so? And there's none given. just the imaginative description of a scenario. And then the question is put, I think, from the common sense perspective of a very, very bright 12-year-old. How can we know what they have if they don't show us, if they won't let us look at it? The obvious answer, I suppose, is, well, then follow the defense request to let the court look at it. But it doesn't quite work that way, of course. The people have turned over what they have, and that is voluminous. Mr. Durst knows what he did and did not do, and if he needs access to something specific to help him prove it, this court is here to protect those rights. Can the defense just say, give me everything in the world that a private person has so I can find something that might help me? No. It must be specific. But wait a minute, the defense is not talking about just any private person, rather the people who investigated Mr. Durst privately and then called the police. And was he indeed prosecuted because of the James? Well, in a sense, but actually he is arrested and charged because of the evidence that is provided. So it's due to the evidence, not due to the accusation. The accusation is not what is at issue, it is the evidence. But in People versus Serrata, where a private company investigated a crime at that company, that's 62 Calat 3rd, page 9, so notwithstanding the fact that a private investigation did lead to the arrest of Serrata, a burdensome subpoena still was quashed on account of its quote-unquote blanket nature. Again, an odd metaphor, but it is a blanket request, a broad request for every conceivable document that might bear upon the case. And Serrata, after describing the blanket, moved to yet another metaphor and said this blanket is but a fishing expedition. I would not mix those metaphors, but still, a fishing expedition is the characterization of a discovery request that is so complete and comprehensive as to ask this company to turn over all of its material. It's too broad and burdensome. Now, that's all right. I want to be specific about the request. I want to focus on the very specific requests and not make a blanket ruling about a blanket request. Let's talk about these 3 taped interviews. So I haven't been given any reason to believe they're of any consequence. I mean, certainly if they were incriminating, they would be used. The suggestion here is they are not incriminating and hence they were discarded, or perhaps they were exonerating. But again, this is entirely speculative. We don't know what they are. So let's return to specificity. If there is something that Mr. Durst needs to prove and he can't get access to witnesses or documents that support that point, specify and you shall receive. But part of the journalist's immunity is that I can't and should not make them simply open their files. There's a fact you need to prove that can be proved exclusively in that way. And if I didn't turn that over, that would not be a fair trial. But to broaden the conception of a fair trial to the idea that a confession can be such a damning evidence, it's maybe hard to overcome. I've been given authority to that effect. Yet there's nothing that is specified that would tend to directly undermine that. There's the question of the authenticity of it. We'll talk about the authenticity of it. And second, the bias of the filmmakers. We'll talk a little bit about bias. That's the closest the defense comes to justifying the request. I recognize there is a theme to the defense. There's a media frenzy villainizing Mr. Durst and driving a rush to judgment. But again, a theme a defense. Now, the filmmaker's process, as you described it, with editing and creation of dramatic effects, may affect the so-called court of public opinion, but it's not material to the evidence actually presented in the case. Again, the idea that this film would be made that is so critical of Mr. Durst may suggest that the filmmakers are biased. So what if the filmmakers hold a bias or grudge against Mr. Durst? And of course, the jury would be so instructed. Any witness could be evaluated for that and should be evaluated for that purpose. As I understand it, the testimony of these filmmakers is simply as to their the authenticating these documents. Now, filmmakers do appear in the interviews, but of course their questions are not evidence. They're evidence in a sense, but much more like a questioner's question is not evidence. The answers are what is evidence. The questions are not significant. So whether the person is biased in asking a question, it doesn't really matter too much. It's the answer that. Asking a biased question doesn't matter. It's the answer that matters. So, is the bias such that there is reason to doubt the authenticity of the confession and of the comparable handwriting? First point here is that discovery, as I understand it, appears complete here. I don't think there's anything specific that is missing here. I guess there aren't emails or letters describing what is actually filmed as far as turning over the handwriting, and that's what I understood. So none of the requests is specific as to the authentication or chain of custody. There's no reason to believe it's inauthentic. There's no showing that there's any reason to believe there's tampering. There's no suggestion of such. And it's not necessary for the real party in interest to demonstrate this, but they've affirmatively documented a report from an independent lab to show that there isn't that tampering of the audio. Do you need to leave?
I do, Your Honor, but I didn't want to interrupt you.
I'll excuse you. I'll get you a transcript of this. I'm sorry that we've been delayed, and I'd like you to.
It wasn't the court's fault. Thank you very much, Your Honor. I look forward to seeing you soon.
All right, thank you, Mr. Lewis. Good luck in that. What's the team called? Go team.
Bears, Spring Branch Bears.
Go Bears. I'm already comfortable saying that, right? So,
With
I
Chip
think
as the
they're
coach.
better than you're on.
Chip is
they're
the
probably
coach.
better than my Bears. My Golden Bears.
They'd have to be.
Yeah.
And Chip is the coach, Your Honor. They're the bad news bears.
I don't want to go out on a limb here, but I mean, there's no claim by the defendant that these are false. So I just mean to mention this because it's the same as the Fourth Amendment. In other words, in that a person can make a claim, they're not waiving any rights about self-incrimination to make a claim that I was there and it didn't happen that way. In other words, a claim can be made and it's not admissible in the trial to prove his guilt. So that's Simmons versus U.S. 390 U.S. 377, right? So there's nothing from him saying that this is wrong, that this didn't happen this way. And Evidence Code 412 says if it's within the power of a party to produce better evidence, and they do not, it's presumed that it's something that can be taken as a concession, really. But even without 412, even without using that idea, there's nothing here to and only the other, only evidence showing that this is authentic. The creation, this recording of the statements and of the receipt of these comparable documents with comparable handwriting. So I don't see anything there. I also have to look about whether discovery is cumulative as to 54 complete witness interviews and all of Mr. Durst's interviews. That seems like a very comprehensive discovery and much material. And there's a question about whether there's an alternative source of material for cross-examination or to prove a case. Certainly the 54 transcripts apply, and whether an alternative source requirement applies depends on the facts of each case. That's Delaney. Yes, that's Delaney. And here, I think in this case, the court may require consideration of the alternate source. In People versus Sapp, the defendant himself can be the alternate source, the alternative source. And People versus Sapp, Calap 4th 240 at page 273. Which means, and I don't think there's anything wrong with that. Sometimes there are burdens placed on a defendant to prove something. Self-defense. How do you know there's self-defense? Well, how do you raise the issue of self-defense? Sometimes a person testifies. And I just don't see the Fifth Amendment problem that is suggested here by the defense. I think he's an alternative source, but 54 witnesses, I think that's sufficient. I wanted to look at the specifics. So the first request is any and all documents related to the HTGR parties interacting or meeting with law enforcement, et cetera, et cetera, et cetera. And the thrust here seems to be discovery to support the agency argument, which is not pending, and the materiality, I think, is, well, it's absent. Again, this whole idea of the bias of filmmakers for turning over the material to law enforcement, the idea that they're biased is not pertinent. And also, there was, I know the defense cited some authority, very interesting, it was in, it was a Brady case that talked about whether or not suggested that that information about an investigation was Brady material. It was interesting. It was, I believe, it was Dixon in that case, because if it's discoverable under Brady, that doesn't necessarily mean it's admissible here or relevant in this case. Well, in any event, I think it's not material, this first idea here of cooperation. And then there's the alternative source, that is, to the extent that the communication went to law enforcement then is revealing it to the defense, their side of the communication. There's no reason to believe they have not. I haven't been told that they have not. Second item, any and all statements and recording of all persons interviewed, questioned, or identified or presented in the jinx, but not limited to all correspondence, all notes, recordings, calendars, lists, or similar items or documents. So that's the closest we've come. As I see it here, it's the closest case, so let me pause that one. The third question, any and all documents, communications, photographs, notes, or similar items or documents provided to hit the ground running by all persons interviewed. All documents, communications provided by persons interviewed. The idea there, the only possible idea here that would work would be that there's something inconsistent. There's some inconsistent statement here, and I'll address that. For all raw footage from the jinx, development, research, interviewing, meetings, negotiating, filming, editing, sale, and distribution of the jinx, clearly overbroad, and to some extent it overlaps number 2, which I'm going back to. 5, the unedited camera master files from the jinx, that's immaterial. 6, all documents and materials that show all edits, time jumps, or similar processes from the jinx, again, immaterial. Not only is there no showing that the meaning of the statements was changed by their order, but it's not even coming into the courtroom. We're only going with the unedited material here. That's all I'll allow in. 7, all production notes for the jinx, immaterial for the same reason. 8, all documents reflect the sale, distribution, assignment, or licensing of the jinx on any platform. That's not material. 9, all documents reflect all public appearances, including TV appearances, interviews, seminars, public speaking by Jarecki, Smerling, Pontier, or anyone else on behalf of the HTGR parties regarding Robert Durst or the jinx after March 14th. So obviously there's an alternative source because they're public appearances, but it's immaterial and overbroad. So let me go back to statements and recording of persons interviewed beyond the 54. And it's really going to be, because you have the 54, they're all turned over. And any and all documents provided by persons interviewed. As to these, I think Sanchez applies. 12 Cal 4th at 1, page 1. The defendant never shows how the information sought would materially assist his defense or how it differs in content from the testimony and published information available for cross-examination. I think this is kind of comparable to People versus Vasco, 131 Cal 4th, 137, 155. It doesn't meet the threshold. It's not significantly different from what we have. Thus, as to the entire subpoena, there's no reasonable possibility that the informational material assists the defense. The motion to compel is denied. The motion to quash is granted in full. All right, let's take a break, and then I will return for the handwriting, Sargon hearing on handwriting.
Your Honor, you just said the Sargon hearing. It's not my understanding that we're having an actual Sargon.
Well, it's not an evidentiary hearing, but I am going to hear now, based on the documents that are provided to me, whether I will allow these witnesses to testify to identification. I'm going to rule on your request to present a witness at trial, and everything that was briefed. We're not calling witnesses today.
Okay.
All right?
There's no one, Your Honor, I don't know whether the court wants to take care of this before the break or after. There's a witness that is in court.
Yes.
That I'm concerned. I want to get this witness ordered back.
Who's the witness?
Yes, so, and because it's Doug Oliver.
Yes, Mr. Oliver is present.
O-L-I-V-E-R. Mr. Oliver is in the courtroom.
Yes.
He has been very uncooperative in any conversations we've had with him.
Yeah.
Because he's in New York and has told us in the past that we'll have to find him in England, et cetera, we would like for the court to order him, either he can be in court on February 11th.
Well,
if
no,
that-
we're gonna be here. I mean, we talked about, a later start, but shouldn't we have an earlier date, or do you want to pick a February date?
Well, Your Honor, this is what I would like, if the court's willing to do it. I don't want to inconvenience
Yeah, I'll
the
order
witness.
that.
This is what I was gonna say. If the court will agree that the witness is to be on call to us with we will notify him 3 days in advance when he needs to be out here, then he can be on call. That's doing a favor to the witness. If not, then we're gonna order him to come back here every time we're in court. It doesn't
Right.
matter to me,
Right.
whatever the court wants to do.
Sure, I don't want to inconvenience a witness. On the other hand, he's been described as a witness both for the people and for the defense, so he's obviously important. I don't mean to inconvenience him, but he has to be here because for the aforementioned fair trial.
Can the court make that order, Your Honor? He's in court right now. Can the court then order him either to return on whatever date the court is going to say, or to order him to be on call with a number to us, given the, what I've described? So in other words, Your Honor, if you don't order him, we don't have jurisdiction
No,
over him.
I'll do it.
Thank you, Your Honor.
So, Mr. Oliver, Mr. Oliver's in the first row. And what other information do I need? Doug Oliver? Okay, and Mr. Oliver, the district attorney, deputy district attorney, Mr. Lewin, has asked that I order you to return to this court, that you be on call, but I not make you come back every time we're in session, but rather to agree, and I will order you, but if it's better, I think this is better for you. So I will order you to be on call to Deputy District Attorney John Lewin, that you return to this court within 72 hours of him giving you notice that you are to be here to testify as a witness in this case. Mr. Oliver, any questions?
Well, I'm in New York, I think 72 hours is, yeah, I do have some.
Very well.
I think you have a reasonable time, be a lot more time, I mean, I don't know. I don't quite understand how this works, but.
A week is fine. Can you also have him give a phone number, Your Honor, that he will respond to? That's been an issue in the past. Well, we can give him 7 days, Your Honor.
How about this? People are nervous about being able to get here on time, so they're talking about 72 hours. If we can get a phone number that's a valid phone number for you, we can make it 7 days. Will you tell Mr. Lewin or one of your detectives to their satisfaction what that number is? Or you don't want on the record, do you, Mr. Lewin?
No, Your Honor, finally,
Do you want me to get the number? I'm asking you to get the number, and then I'm going to make it 7 days, but let's.
Okay. Yes, you're asking me to walk over and get the number, okay? I'm sorry.
Detective Shannon will get the number.
The detective Sandlin, okay.
Your Honor, the final issue on this.
Let me make the order. You agree to give the phone number?
Certainly I'll give you further, but 7 days is, I travel a great deal, and I really need much more time, because it so happens that I know in the month of February I need to be in Singapore. I don't know the exact date, so.
He'll work with you, but I'm giving you 7 days.
Your Honor, and the last thing, could you advise also the witness, he has requested before that the only way he'll come out here, quote, he will not fly commercial, we need to pay for the fuel for his private
That is
plane.
not so,
We
sir.
have informed him that the
Your
county
Honor,
does not
excuse
do
me.
that. Can you please let the witness know that he's going to have to fly out here, coach like any other witness, and that we will not be paying for gas for his private plane or flying him in a different style.
But you will pay airfare.
We'll pay airfare, he'll get a coach seat
Yes,
like
Mr.
everyone else.
Chesnoff.
No, I just want to move things along, Your Honor, because unlike other people, I have other things to do.
No, we all have things to do.
Yeah, I understand.
It's important.
So here's the other thing, Your
Mr.
Honor, I don't think the record should be that he has not been cooperative. I don't know the interaction, but not wanting to talk to a DA is a right of an American, so I would characterize that as uncooperative.
Okay, well, whatever it is, I'm ordering you, sir. I'm giving you seven days. You got some reason. These are not actually unreasonable people, and you'll find out. So but they're firm, right?
Yes, Your Honor.
So 7 days from contacting, you'll give your number to the detective, and I order you to return to this courtroom with 7 days notice from Mr. Lewin or his team at the LA County DA's office.
I have to,
Thank you, Your Honor.
Yes. Now, I wanted to get my materials because I couldn't carry all the handwriting and the quash in one trip. So how many minutes you want to take your break? 10 minutes? 15? Huh? 10? It's early, but we're break early.
Your Honor,
He doesn't want to give it to me.
I really,
he's not giving
gentleman
Detective
has his number,
Shanley.
I really don't want to give my number, I don't trust him. I'll give it to you, sir.
I'm not calling. I don't call witnesses. Yeah. How about this? How about I
I've
make
been
it
doing
72
several
hours?
times with this gentleman, I really don't want to be called. How about if you give it to one of these gentlemen here?
Pointing to the defense attorney?
Yeah. This is how it's been, Your Honor.
Yeah, I get it. So if you want 72 hours, it's okay from, you put it on the defense.
No, we want his phone number from him as the court ordered.
That was actually voluntary. I don't know if I can compel phone numbers, I can compel a tenant.
Just whatever.
Yeah, you know what, Your Honor, let's make it easy. Just order him to be back in court on the next court date. We'll have him come back here every single court date. If that's the way he wants to do it, we've tried very hard. He doesn't respect anybody's authority.
Listen, right, I mean, right, if you order him back, if he didn't show up, then I put out a warrant. It's easy.
Your Honor, can I just inquire,
Yeah.
because I understand from what he was just saying to the detective that Mr. Lewin already has his phone number.
Well, the problem is I continue to call, he doesn't return phone calls, and I know what's gonna happen because it's happened already. He'll make an arrangement to make a call, he'll then say, I was on a plane, I couldn't call you, I'm in England, don't bother me.
Well, on call doesn't sound very good then, does it?
Your Honor, I'm trying to work with the man as best I can, it hasn't been easy.
Your Honor, I think that the court's order says he has to appear within 7 days of receiving a phone call. If they have his phone number, tell him to call his number, leave a message, document it. If he doesn't show up
How
within
about
7
this?
days.
How about I order him to come back and you can make arrangements if you're satisfied with him to come back on call?
That's good, Joe.
I'll put him, yeah, good?
Yeah, perfect.
Okay, I want to keep that date, the January 13 date.
Perfect.
So I'm going to order you to return Mr. Oliver to this courtroom on January the 13th, 8:30 a.m.
Thank you, Your Honor. Your Honor,
Yeah.
and maybe
20, January 13th.
13, depending on the court's time, how the court wants to do it, there's an issue regarding how we will end up handling Mr. Drecke, Mr. Smerling, Mr. Pontier's testimony. Because their attorneys are here today, I was hoping that we could briefly, with all the attorneys, speak in the back, either depending on the court schedule and their schedule, before we do this handwriting motion, or after, so that we take advantage of the fact that the lawyers are here, because there are some issues that I think would be helpful to get out today while everyone is available.
Okay, who's catching a jet? Raise your hand.
I volunteer.
Not the audience, but thank you. I'm on counsel.
Your Honor, when court is over today, I am going to visit a person in a lockdown psychiatric facility where I may choose to stay.
Yeah, me too.
But I really don't have time today to accommodate.
For that part?
Yes.
Because I've never heard of that.
We'll try anyway. We'll see how expeditious.
Thanks, Your Honor.
We'll do the handwriting on there. Okay?
Thank you.
Because when is it?
10 minutes.
Your side of medicine. Handwriting Evidence. You guys have to go this
You'll just have to drive.
I'll take it. Where do you need to go? You need to go someplace where we're not?
Four of us.
That's the advantage of being a defendant.
It was fun. No, well stressed. We just talked science and law.
And Mike's on there.
Okay.
Where's the half machine?
you left?
She left for the panel.
I had stuff here I wanted to take with me.
You can't take stuff. That doesn't.
I don't hear it.
You can't take stuff.
I don't hear it.
He said you're not allowed to take the stuff back with you.
Tell Catherine to give it to Stephanie to bring it to me.
Okay. You got it. There's.
Yeah. Thank you.
All right, we're back in session. People versus Robert Durst. Mr. Durst is present with Mr. Chesnoff and Mr. Ray, and Mr. Lewin and Assistant Head Deputy Bailey and are present for the people, and Mr. Beata, Ms. Milius. We now are going to hear the balance of the argument. Like the last argument, this is broken into parts by necessities. This is the defense motion to exclude evidence of handwriting comparisons under Sargon. And of course, I've read your authorities. So,
Your Honor, the court last time we were here, when we had the benefit of a transcript, did a very thorough outline and analysis of the position that we had taken. And in response, the state filed various declarations in order to supplement their position, which most respectfully, Your Honor, we don't believe the declarations actually moved the ball much forward in terms of the state's position. We still maintain that Mr. Muhammad should be excluded from trial. Basically, Your Honor, his declaration simply vouches for Mr. Cunningham, and at best would be considered cumulative. Mr. Osborne should be excluded at trial. As the court recalls, he was first retained by Mr. Jarecki. He didn't submit a declaration and would also be cumulative to Cunningham. At most, Lloyd Cunningham should be permitted to testify. You already stated that Mr. Espley and Supervisor Connor from California DOJ cannot testify. The only thing that Cunningham really talks about is that, to some degree, that Muhammad's initial reports were conclusory. Cunningham should be strictly limited to testimony regarding the alleged similarities and lack of similarities in Mr. Durst's writing and the cadaver note. He cannot, as the court stated at page 41 of the prior transcript, lines 1 through 11, opine specifically that Mr. Durst is the author. As to Cunningham's other opinions in his declaration, the court merely has to track the arguments we made in our supplemental brief. Cunningham's opinions are based on his experience and not supported by the reliable methodology that this court has already acknowledged is necessary. With respect to the question of whether or not we can raise during the trial the reports of the supervisor and the original handwriting examiner that another person actually wrote the note, the court, as well as the state, have acknowledged really how terrible a job those people did and how actually it could probably border on some form of obstruction, and said that they wouldn't be allowed to testify. We have asked in our supplement, Your Honor, and the court allowed us to do so, to consider allowing us to bring out the fact that another person was identified, not for the purpose of doing anything other than establishing that there were other suspects and that police investigative tools do not always rise to the level they should, and it would provide the jury with the knowledge that handwriting people can be wrong. And in fact, police handwriting people can be wrong. So we would ask you not to allow us to introduce those reports necessarily for the identification they made, but rather for the fact that the state and the court have recognized that that identification was faulty, especially in light of the perjury, or I don't want to call it perjury because it wasn't under oath, but the lie that was told by the supervisor, who later acknowledged that she only rubber stamped it. We feel very strongly about that, Your Honor, because in the course of our defense, there will be multiple representations about the way the investigation was conducted, especially in light of the fact that there has been a concession already that there's absolutely no forensic evidence having been retrieved from the scene, even though there's multiple possibilities of other people that we will present at the time of trial. Not necessary for us to preview our defense, but with that said, Your Honor, I don't think anybody should be allowed to testify that Mr. Durst is the author of the cadaver note. I think the court has observed what is allowed and what is not allowed. They can give, Mr. Cunningham can give his opinion as to why certain thing, but the ultimate decision is up to the jury to decide, and the court's going to so instruct. I might review my notes for a moment, Your Honor, knowing that you've been through this before. But with that said, Your Honor, I think the strongest thing that can be said is that the declarations do not necessitate now a Sargon hearing. I think the court can garner enough from what we've argued and what they've written to make a reasoned decision as to what should occur going forward. If you have any questions, Your Honor, happy to answer.
No, thank you.
Thank you, Your Honor.
Your Honor, I want to address this very carefully and very completely because this is an incredibly important issue. The handwriting evidence in this case is absolutely central to the people's case. And I want to start with how we kind of ended up here. We ended up here because the court made the observation. The court said, quote, "I believe that even a handwriting expert proffered under 1418 likewise ought to be screened. I don't think that's a difficult task." That's what the court stated. That was during the July 17th hearing, page 25, line 27 to page 26, line 3. Now, the court also said, as the court remembers in dealing with this issue, the court said that the reports that the court had from Lloyd Cunningham and from John Osborne were incredibly detailed. The court noted how helpful they were. The court specifically said, in at least 2 instances, the experts have offered superior handwriting comparisons which are quite methodical and thorough. As the comparison of writing, Lloyd Cunningham's methodology is exceptionally useful. It will assist the jury in its comparison of the documents so they may fulfill their fact-finding rule under Evidence Code section 14:17. The court added, "I'll turn first to the opinions of Lloyd Cunningham. His observations, his analysis are extremely methodical, very, very useful." Sure. The court added, "I'll turn first to the opinions of Lloyd Cunningham."
So, I'm sorry, I said this and now there's a transcript of it. It's in your brief and now you're saying it again, which is now going to be in another transcript. So there's this echo thing going on. But I appreciate, you need only reference the point and I will instantly apprehend what you mean.
Understood, Your Honor. So the court indicated during this ruling that the court's position was that these experts had not laid out the complete methodology and, in essence, the reasons why they came to the conclusions they came to. Now, the court mentioned, with respect to methodology, with respect to opinions, the court discussed 2 that I recall. One was, the court said, listen, your expert is saying no 2 people write the same thing the same way. And the court said, hey, where is the authority for this? Where's the, et cetera? The court said the same thing similarly to no person writes the same thing the same way twice. Now, at the time, we related to the court, Your Honor, part of what's going on is that you have experts who are writing a report, and as detailed as these are, it would be nearly impossible for an expert to go through and defend and articulate, almost defend their thesis to that degree. We went out, Your Honor, based on the court's ruling, and we paid these individuals a lot of money to go back and here's the issues, here's how you came to the conclusions, which they did. Now, it's important to note, we still have not heard from the defense, Your Honor, one declaration, one witness, one iota of evidence that anything that these individuals did was improper, was not, if I can continue, was not within the standard of a handwriting analyst. What we heard was, we have a law professor who has been specifically prohibited from testifying to this kind of evidence in a Cal Supreme Court opinion in Lucas.
Right, but remember, this was at the admissibility hearing that he could not testify. And as to the question of whether he was improperly prevented from testifying at the trial, the defense took the position that it was futile because the trial court had disallowed the testimony at the hearing. The opinion, the Supreme Court says that's not so. That's they didn't actually decide the point of whether he ought to testify at trial because, or whether it was admissible at trial because the question had not actually been presented.
Right, but this is the admissibility hearing. So, Your Honor.
Right, I won't hear,
Right.
just as in that case, I will not hear from that expert at the admissibility hearing. I'm gonna rule, and you may argue whether or not he ought to testify at trial, but that's not gonna be the reason.
Right, and Your Honor, to continue, what that expert put in his declaration, and again, even after we filed our supplemental declarations, which Mr. Chesnoff said were insufficient, they quote, haven't moved the ball, etc. I don't know how you can move the ball anymore. They're about 50 pages long each. I'm very comfortable in saying I don't think there's been a handwriting expert in any case in the history of the United States of America who pre-trial in a criminal case has submitted this kind of validation, justification, methodology for the opinions that they're going to give.
It's about time.
Yeah, so that is kind of step one relating to this issue. Now, the court, Your Honor, and this is partially our fault in apparently not explaining to the court a little more carefully about Linton Muhammad. Now, I think his declaration spelled it out. Linton Muhammad was assigned to do the same thing that Karen Chiradi was supposed to have done originally. Now, Linton Muhammad did an independent examination. He made his determination independently, but as happens with the ASCLAD rules, ASCLAD, that the laboratories have to follow and which many expert witnesses in the field of forensic document examination follow as well, you have to have a second person sign off, look at the original results, come to their own independent opinion, and then sign off on the other person's report. So, Your Honor, it's not that Linton Muhammad did not write a report. His report is absolutely, Cunningham's report is adopted and included by Linton Muhammad. And I think now we've spelled that out in the declarations. Now, with respect to Mr. Osborne, we have chosen at this point in time, he is very likely, if we call him at all, going to be a rebuttal witness. If and when we get to the point where we are going to offer Mr. Osborne's testimony, we will file a similar declaration. Now, one of the issues that is hanging in the background is as we sit here, Your Honor, we still don't know whether this is even going to be an issue. We have not been told yet whether, in fact, the defense is even going to contest the handwriting. But let's assume, and everything I'm going to argue has to do with the idea that they are, in fact, going to contest the writing. So, let me just, because I don't want to go through it more than I have to. Does the court need any further argument about the peer review issue with Linton Muhammad?
No.
All right, so does the court need any further argument? I did not, as the court's aware, in our moving papers, I did not go back and go through each opinion that the witnesses gave in their declarations and explain them. I assume the court doesn't want or need me to do that now, am I correct?
That's correct, Mr. Chairman.
So let's move on to the next issue, which is crucially important. 1418, Your Honor, is very clear that a qualified expert, and these experts are more than qualified, can testify to identity. Now, there is nothing that is in Lucas which in any way changes that. And I just want to address...
Don't make this argument.
Your Honor...
I guess it's good for you. I mean, that you have another basis to uphold what you expect my ruling is going to be. But seriously, if the argument, if Sargon didn't exist at the time, and so no one's going to make a Sargon objection at trial, therefore the Supreme Court's got no business applying Sargon after the fact without a factual basis.
Your Honor,
I know you. I understood your argument, but it's like you want to win every argument. You don't have to win this because I don't think it's true. 1418 is necessary but not sufficient, right? Let's say you've got 1418 that says they can give an opinion. What if the opinion is somebody quoting somebody else who read in a book that was the opinion? It's hearsay. It doesn't come in. So 1418 lets it in, but it doesn't always let it in. Likewise, if there isn't a foundation, a soothsayer told me, I visualized him writing the notes, for instance. Imagine that.
Right.
Is that now admissible because of 1418? No,
Your
it's
Honor,
not. So don't make that argument.
Then let me ask the court this, Your Honor.
Yeah.
Do I need to, at this point, do I need to spend more time explaining to the court why these experts should be able, under 1418, and given the declarations they filed, to be able to give an opinion on identity?
No, I think that you've done what I asked.
Okay.
There's one little caveat. I'm going to go into it, and we can talk about
Okay.
it.
Then I'll hold off on that for now.
Okay.
Then let's go to the next area, which becomes important. And this is, it was very confusing. Defendant, I'm going to talk about Denbaugh for a second, and this is going to go whether he's called a trial or not called a trial, but this is the issue that we're going to have. One of the problems is that Professor Denbaugh, in essence, wants to say that handwriting and handprinting are not reliable. He wants to talk about other states that don't admit it, etc. He wants to talk about how handprinting is different than handwriting. And here's the issue. The problem is the Cal Supreme Court has rejected every one of his positions. So the question would be, if he's going to testify, is an expert with the court's gatekeeping role, is it proper for an expert to, in essence, say, listen, handwriting's garbage. I don't care what the Cal Supreme Court says about admissibility, so then what do? Do I call, the Cal Supreme Court here to testify? Do I have the court take judicial notice and read to the jury that, in fact, the Cal Supreme Court has specifically stated that handwriting is admissible in California? That
No, admissible is not relevant. So the question you're posing is, does he in fact have a basis for the assertions he's making? So merely because something is admissible doesn't mean that the jury must automatically accept it. So the defense must be allowed to, with admissible evidence, if they like, contest the accuracy or reliability of the handwriting comparison in this case. And so part of that might be an expert opinion that no one could ever do such a thing. If there's a basis for that, whether or not it's inadmissible in other states, I don't think that comes in. But I am willing to scrutinize the testimony, but as a general principle, I don't think I exclude it simply because the evidence, the contrary evidence, is admissible.
Oh, Your Honor, I want him to testify. I'll gut him like a fish. The problem is going to be,
again, a sports metaphor.
The problem is
Not
going
if
to
you're
be,
the fish, you know.
I just want to give real clear warning and information to counsel that if you're calling somebody who's going to attack the whole field, who's not even a handwriting expert themselves, then this is the cross you're going to get. But so moving on from that,
I'll let him know, Your Honor.
okay, we now move into the whole issue of believer and charity. And I think it's important to look at the history.
Yeah, I'm not going to let it.
And the third-party culpability argument, I just got to say this. It's, I don't know, disingenuous, malformed, but here's the argument. We want to bring in the misidentification of Niall Brenner. We want to bring it in to show that Niall Brenner actually wrote it, but we don't want to bring it in for the truth of the matter asserted, but it's actually only relevant if in fact he wrote it, and we want to bring it in even if none of that matters because we want to show that the investigation is corrupt. Wow. That's a handful and it's got 352 written all over it. So, Your Honor, with that in mind, I think this is for me one of my shorter arguments ever. Based on what the court has said, Your Honor, subject to the quote, I think you call it a caveat or whatever, the caveat, Your Honor, we'll submit.
Do you wish to respond now?
Only this, Your Honor. The court has indicated that you might rule against us on the issue of whether we can present the information to the jury that police investigators in this case made a dreadful mistake or had a theory and then lied about it. If the court's going to deny that, we have a record made on why we think that the jury should be able to hear that the LA police investigation was flawed With that said, Your Honor, I have nothing else to say.
Okay, well, we'll talk about that, and of course, you phrase it as persuasively as you could, but I mean, it's based, first of all, on bad science, and second of all, on we'll talk, again, I kind of previewed this when talking about the difference between a theme and a defense. You may get in evidence, there may be evidence from which you can imply that the investigation was done poorly. But as far as presenting a case about a bad investigation, that's not going to be relevant. It's not going to be relevant. So I'll discuss it specifically. Let's just go over what we're doing here. So Lucas holds that the method of handwriting comparison offered by the prosecution was not sufficiently scientific to require a hearing under Kelly. We agree with the trial court's determination. The handwriting comparison utilized here merely isolated and carefully compared readily observable aspects of physical evidence. So we're not really talking about scientific testimony. We are talking about expert testimony, and my main concern for the jury with expert testimony is this. The testimony can't be ipsa dixit, which is really fun to say. Ipsa dixit. It can't be, I am an expert and I say this is so. And that's not good enough. And I'm obviously saying it in a tone that emphasizes its possible abuse. And not that the experts aren't trustworthy, but even if it's not science, still there have to be objective bases. There have to be guidelines and criteria for rendering an opinion, and I need to know what those are. So there are references to various ideas in handwriting comparison that were not supported by anything. And you've explained why that was so. So now I've asked for you to document the basis for such opinions. Now, you know that I've spent a lot of time thinking about DNA evidence, and that's the gold standard. It's quantifiable. It's
science.
You know, it's science, and it's probabilistic. It's more, I think, more reliable. So, nevertheless, any expert testimony, whether scientific or not, still needs those objective bases. So, even if evidence is let's say, even if I'm skeptical of evidence that's presented, that's not my job here to decide whether I am skeptical of evidence. What I need is what Sargon commands, and there is reference to Comparatively and Daubert, and those cases that describe the what is sufficient and what is not, as far as the basis for an expert opinion. I would say generally that what I've seen here is voluminous. Certainly, it's consistent, and it's pretty convincing. I'd say that handwriting can be individualized. It's not scientific per se, but it is supported by more than mere opinion. Let me talk about these things specifically, and I'm going to contrast what is supported by something that is not, with something that is not. do think the defense brief is a good guide. It was well organized. All right, the argument is that John Paul Osborne should be excluded from testifying at trial. The people have indicated they're going to file a brief if he does testify. I think he may rely upon the support for some of these ideas generally supplied by the other experts. In other words, I don't really want to have each expert testify to the basis over it. That would be cumulative. Whereas the shared notion of what a proper basis is for an identification, I think is sufficient.
You know, on that issue, what we would likely do is, given what the court has said, we would likely have Mr. Osborne look at the declaration, and then affirm that he agrees or does not agree. And if he agrees with it, we would file simply a declaration saying that he is incorporating those two declarations into his opinion. And as the court very soundly realized, it's supported for any handwriting expert, the position in there. So that's what we'll do if the court is, if that's acceptable to the court.
So I ruled previously that he may testify, that Lynn Muhammad may testify, that Lloyd Cunningham may testify. First of all, the defense specifically complains about that Mr. Durst tried to change his handwriting where there was alleged unconscious reversion. And that's interesting. I think there's a reason that was put first, because immediately I was skeptical of that also. And I think the problem here is not substantive. I think the label is poorly selected. This idea, unconscious reversion, they picked this term to describe this dynamic that is described by a number of studies. Now, unconscious is a Freudian or Jungian notion, and we're certainly not going to hear expert testimony about that. These folks aren't psychologists, so I do think it is the label is inapt, but functionally, substantively, there is support for this idea of reversion to one's prior style of writing. Secondly, the defense objects that Mr. Cunningham should not be permitted to introduce his opinion that no two persons write exactly alike, that frequent repetitions by one individual establish habit patterns that are difficult, if not impossible, to imitate successfully by another. There were quite a few studies here. Now, some of them are conducted by Mr. Cunningham himself. I don't think that necessarily eliminates that from consideration. It's more than a mere guess. It is actually objective. It can be criticized. The lack of peer review on some of these is significant. It could be a basis for exclusion, but it's not the only consideration in determining whether or not expert testimony is sufficient to satisfy Sargon. Again, I'm not here to judge whether this is persuasive. I'm here to decide whether there is some logical basis, some reason, some evidence to support the idea. The third complaint is Mr. Cunningham should not be permitted to introduce his opinion that two bodies of handprinting can be deemed to be the handprinting of one and the same person only when they agree in every fundamental element and quality, and if they embody no basic differences. I found support for that in the materials. He should not be permitted to introduce his opinion that no person writing freely and normally ever writes the same thing in precisely the same way twice. There is evidentiary support for this. Mr. Cunningham should not be permitted to introduce his opinion that frequent repetitions of the writing act by one individual establish habit patterns that are difficult, if not impossible, to imitate successfully by another. So there is a criticism that impossible in the defense views hyperbole. Nevertheless, that conclusion, there's support for the conclusion. don't know that it's undeniable, but there's support for the conclusion. So it would be admitted, Mr. Cunningham should not be permitted to introduce his opinion in the cadaver note and the envelopes were spontaneously executed. Moreover, he should not be permitted to opine that there is no handprinting evidence to indicate that another individual attempted to imitate Mr. Durst's handprinting by freehand simulation or tracing. I believe that was supported by the declarations. Now, we get to those are the complaints about from the defense. There is still one element of this testimony on which I am not satisfied, and I'm skeptical that I could be satisfied, and that is so I see in every instance there's an objective basis for identification testimony. I do not see the objective basis for relative confidence. So the justification for this, and it ostensibly protects a suspect because a person is very confident or kind of thinks so, or think not, that maybe, that those kind of terms, I'm obviously mocking it by putting it in different terms. They actually put it in pseudo quasi-scientific terms, which I think lends a scientific veneer to opinions that are not scientific. And the justification for this is reference to the Scientific Working Group for Forensic Document Examination Standard Technology, SWIGDOC. And SWIGDOC is, so it's a committee that decides a fair way to express these things, and it may well be fair, but what the people have shown is something that is binary. It is or it isn't the handwriting of this person, and various related claims, which, but as far as the identification, it's binary or not. And I think the degree of confidence, the connotation of confidence is, it suggests that it's probabilistic and quantitative when it is not. So I just don't feel there's any support for that other than a committee agreeing on language. So that part I wouldn't allow.
Your Honor, just so it's clear, because I want to advise our experts, so it would be my understanding, first I want to say what we can't do. We cannot have the expert get up and say, to a reasonable certainty or to a reasonable scientific certainty, I believe Robert Durst wrote this.
Yeah,
we understand that's out.
Yeah.
If I explain to them what I believe they would say is based on my experience as a handwriting analyst, based on my training and experience, it is my opinion that Robert Durst is the author of this document. Am I correct?
That's right.
Now, then the issue would be that in cross-examination, the defense has to be very careful not to open this thing up, because in the end, Your Honor, they can use your ruling as a shield. They should not be able to use it as a sword.
All right.
So, Your Honor, if the defense starts to ask questions on cross-examination regarding how certain are you, what is the basis of your certainty, et cetera, they're potentially going to elicit a response from the witness that, in other words, I'm trying to tell my witness what to say, but they need to understand that they can open a door they don't want to open. Fair, Your Honor?
Right, and they'll hear the jury about SWIGDOC. Okay. So now let's move on to the next, we've gone through the shield, now the sword. So the defense should be permitted, they claim, to introduce evidence that Niall Brenner submitted writing samples to LAPD, William Weaver, and Karen Chiradet, I forgot what's her name, identified Niall Brenner as the author of the cadaver note, and subsequently changed that assertion to implicate Mr. Durst. So, first of all, the science was junk. There was a lack of methodology here. It was false. But then we just don't have, satisfy the admission of People versus Hall. It's not, so supposed evidence of motive is not enough. Motive, opportunity, it's not enough. There has to be actual evidence connecting this third person to the commission of the crime, and there is no such thing here. Here is, and I misspoke earlier, here's where the defense quotes Kiles versus Whitley, which is really, really interesting, because Kiles versus Whitley says, it does say, defendant is in that case was entitled to discover evidence to attack the reliability, thoroughness, and the good faith of a police investigation. Interesting. So it's dictum. Secondly, it's federal, it's a constitutional right to discovery, but it's not, this case doesn't stand for the admissibility of this evidence in this context. You can't say, well, Kiles versus Whitley means that we get to put in evidence of third-party culpability on the grounds that it shows us the police, blew it, not identifying this third party. But it's a red herring, right? So it's.
Your Honor, could I just make one comment? The point I think of the evidence from our perspective is you had an investigative team that had a suspect, and so they produced the evidence to go after that suspect. They then later had another suspect. They decided to produce the evidence for that suspect. That is relevant to determine not only the reliability of the methods they used, but the reliability of the investigative team to actually produce the truth.
Okay, so the reliability of the investigative team to produce the truth is irrelevant. That is immaterial. What is relevant is the evidence that the witnesses testified to. Okay, their investigation is not relevant.
No,
the jury will not be told consider the reliability of the investigation, their capacity to produce the truth. They're not going to hear that. It's not material. And then the other part is the evidence is false.
Respectfully, Your Honor, if in fact there's an investigative team that decided to set somebody up because they figured that he was the one who did it, and then they decided to focus on somebody else, and they switched and said, okay, we're going to set that person up, that clearly is relevant to whether the jury should believe anything that they are told by that investigative team. And so that's what we're saying here, is that you have a situation where there is, we believe, an evidentiary basis to be able to say you cannot trust what you're getting from them at all.
I see. So the police officers suspected someone, and then they go to a handwriting expert who does a terrible job, and had the handwriting expert done his job, he would have ruled out Niall Brenner. But he didn't. In fact, he's rubber stamped. And then he's and then we see that this was a rubber stamp. So now you're blaming the police officer and saying, when the officer testifies, and what the officer testifies to, I'm not sure, the condition of the crime scene, the fact that they talked to the defendant. What are they testifying to that either? I mean, this is.
It's the bias of the team that we're talking about.
And the bias of let's say the team is biased, then what? What's that for?
The jury doesn't have to listen to what they say. It has a reason to disbelieve what they have said about other issues.
And I see. And what specifically is it that that you suspect that the officer will testify to? This is not a drug bust. This is not the officer saying, I caught the guy with the cocaine. This is the officer who amasses evidence of other people's statements.
But there are examinations that are done at the scene of the crime, which are then interpreted. They're pointing the finger at this.
I see. So okay, now you're talking about the scene of the crime. So you're talking about you're attributing. You're attributing to each member of the team that collective bias. So it's a conspiracy that you're proving.
One that we can argue, yes.
I don't think a defendant is foreclosed from telling a jury that the police engage in misconduct, and that's a basis for not convicting somebody.
Wait. If there's admissible evidence from which one can infer misconduct, go for it.
Well,
you have at it. But you have to get the evidence in. It has to be admissible evidence that the police officer, didn't look under this rock over here. I mean,
but you're up.
If he's at the crime scene, sure, I get that. That's different, though. But you're talking about an unrelated activity. Not only that, this is complicated by the third party culpability, which is clearly not admissible, and for a good reason, because it's a red herring.
Your Honor, this is an extension of the crime scene investigation. This is a note that's found at the crime scene. They give it to the investigative team. They have a suspect who is Niall Brenner. Lo and behold, this junk science handwriting points the finger at him. We don't know to this day it wasn't him who wrote it. The only reason we say that now is because they produce other experts that say it's Mr. Durst, but they could...
And Mr. Durst acknowledged that the handwriting looked pretty similar.
Well, but
I recall that testimony.
Yeah, to be clear, Mr. Chesnoff has just said that the cadaver note was found at the crime scene. The cadaver note was not
I didn't mean it...
No, but it describes the crime scene.
Right.
Clearly, it's inculpatory.
Your Honor...
But may I finish, Your Honor?
Yeah, it was gathered by law enforcement. They gave it to this officer whose credibility I should doubt because he focused on the suspect and got a bad handwriting report.
A suspect who they knew had failed a polygraph about this, by the way, Your Honor.
That's also...
Wait, Your Honor, they're mentioning the... Your Honor, can you...
I'm interrupting, but you can.
Wait, Your Honor, can you admonish them? Your Honor, it's misconduct for them to be discussing Your Honor, tell me I'm wrong that the code... Your Honor...
You're procedurally wrong. Lady Dagger, that's the thing.
Wait,
you might be substantively wrong. You're procedurally wrong.
Come on, they cannot. They're bringing up polygraphs, Your Honor, which are absolutely inadmissible in the middle of this case.
Yeah, it's bogus.
No, but you can't do it. It's unethical and it's unprofessional.
Your Honor, I'm not.
That's why you have the code section, Your Honor. Tell me I'm wrong.
Okay, so you're wrong. So when I finish, I'm not bringing it up because it's a piece of evidence. I'm bringing it up because it was an investigative tool used by the police, and then lo and behold, the guy that they utilized the investigative tool is identified as the person who writes the note.
Yeah.
Then they switch to Durst. And now all of a sudden, this guy doesn't know what he's talking about, the supervisor's a liar, and we're not allowed to tell that story to the jury, Your Honor? I don't understand it, to be honest with you.
You're on the other issue that this brings up.
Okay, wait a second, no, I'm still dialoguing here with Mr. Chesnoff because of the question and answer here. So,
do we get to dialogue too, Your Honor?
Yeah, we have dialogue too.
All right.
The jury is entitled to the entire picture of what occurred here.
Well, that's how People v. Hall says.
Right.
Right?
What did you say? I'm sorry.
People v. Hall says you might have some evidence pointing to a third person, and that doesn't come in, does it?
I understand, Your Honor, but we are talking about a completely circumstantial case without any evidence of forensic value except this note, which they are going to use these quasi-scientists to explain to a jury is the aha moment.
I get that part. I mean, you can certainly attack that, and I think it's vulnerable to attack. But this, you can't put in this red herring because it's false on multiple levels, and it doesn't legitimately raise a reasonable doubt. Now, you're trying to say that means. You're trying to suggest, I guess, So wait a second. They're biased. We understand this. So if they're biased against Durst, why are they trying to frame Mr. Brenner? They're trying to frame Mr. Brenner, according to your theory. They're wrongfully going after him. Is that it?
No, Your Honor. In other words, what you have is they first are looking at this. They think Brenner did it. It's a bias at that point against Brenner.
I see. Once they have evidence, then they want to prove their case and close it. That kind of thing.
Or once they have somebody that they think did it, whether they have the evidence or not. Once they have something that points to that person, they want to get the evidence together that's going to be able to allow them to prosecute it.
So you want to have a pattern and practice is one instance? Let's say that was so. Or do you introduce other cases where they started on the wrong guy before they got the right guy?
If you have a situation where this investigative team goes after somebody because they want to go after him to the point that they actually get a handwriting, and then the handwriting is then approved just with willy-nilly without even really examining it by the supervisor, you've got a situation where somebody is being set up and they're willing to do it because they, I guess, believe he's guilty. And then when they switch and they say, okay, well, we believe this other guy's guilty, boom, we do the same thing to him. And that's the argument that we're making. And if in fact it's really outrageous, forget about the handwriting, because in terms of whether it's reliable or not, you then have a supervisor who just says, yeah, that's it, that's the guy. On a murder case, you're just gonna stamp it or something?
Wait, but didn't she do, I don't think this is the only case. I'm not sure about that.
We don't know, we made a request for her files, Your Honor.
Right, no, I think that's pending today
Yes.
too, isn't it?
Yes.
So, well, not,
Your Honor, the court made a determination. I informed the defense the day that you made the decision,
Yeah.
telling them that if they want to go to the court to get a copy of that information, that apparently the court's going to be deciding whether the court will give it to them or not.
no,
They haven't, so there's nothing pending, we're waiting for them to get it, and if they get it, if the court decides that they get it, then we have a right to get it as well.
I think I do that in open court, don't
Yeah,
I?
yeah, court might decide either way. Your Honor, I just have to add that, first of all, because it's gonna be an issue that's gonna come up repeatedly, the defense counsel likes to talk about this as a, quote, circumstantial case. Well, there's a lot of circumstantial evidence. We also have what you can characterize as 3 different confessions. Confessions are not circumstantial evidence. Confessions are direct evidence. In fact, just so it's clear, we will be arguing when we get down to jury instructions that the circumstantial evidence instruction will not be necessary in this case because there is other evidence, completely direct, 3 confessions that an individual, just based on any one of them, could certainly decide Mr. Durst's guilt. Number 2, what we really have, Your Honor, and the defense has been very clear, and they've been somewhat transparent about it. The first motion they filed was, your LAP experts are not credible, they're horrible, they shouldn't be able to testify. We tell them, we agree with you, they absolutely shouldn't be able to testify. They then realize, wait a minute, we want to put on a dog and pony show, putting LAPD on trial, etc. We want them to testify. So then they come up with, when they lose the Sargon issue, they say, well, you know what, though, we want to bring it in for a completely unrelated purpose, third-party culpability. They don't come close to meeting Hall. Again, and the court, gave a pretty easy synopsis. It's pretty simple. In the end, what conspiracy could there be? One person made a mistake and one person committed misconduct when they identified Niall Brenner. They said in 2003, 12 years before this case was ever filed, 2002, excuse me, 13 years, they said that, in fact, they made a mistake and it was not Niall Brenner.
So let me give you a hypothetical. Let's say that if the point is not to say that Niall Brenner did it, but the point is to show that the officers were biased. What if...
Wait, which officers? The officers?
Yeah, I mean the whole team, I guess.
Well, you have to...
Well, I don't know, but let's just to set that aside for a moment. Well, we'll get back.
Yeah, it's kind of setting aside the whole...
The police, the police were biased against Mr. Durst. So, now, to that point, let's say that they say you investigated someone else. You had a handwriting, you took a polygraph and a handwriting exemplar, and you turned out he wasn't the guy.
Well,
or you want to add that they want to add that.
First of all, as the court's aware, the mention of a polygraph, either the offer to take or the results, is inadmissible in a trial, in a pretrial motion, in a courtroom.
It gets in though. It gets in when people offer to take polygraphs, or
Your Honor,
threatened with a polygraph, and then they testify.
Your Honor, it gets in.
It does come in.
Your Honor, it gets in.
I know it's inadmissible, but it comes in sometimes.
It can only come in under law if both sides stipulate that it comes in. We're not going to stipulate.
Right. No, I don't. It shouldn't come in. But this is a hypothetical here.
It's a scary hypothetical.
Okay, I'm sorry. It's scary.
It's a scary hypothetical.
This week. All right. So, is there some basis for? Isn't there some basis for impeaching an officer for focusing on a person and going to great lengths to try to demonstrate the person is guilty rather than to rule them out?
No, here's the problem that you have. First of all, these are not officers. These are forensic document examiners whose only part in this case, they were not part of the investigation at all. They were to do one thing. They were to look at the writing, and they were to give a determination whether or not it matched other writing or didn't. One person screwed it up, by their own admission, made a mistake, an honest, but a mistake of competency that goes to Sargon. The other one didn't even look at it. So obviously, there can't be any, at that point in time, there's no investigation that's going on.
So then do they employ the LIE detector?
Wait. You mean you're asking about the order of what happened?
Yes.
Well, I mean, gosh, I hate even dignifying it, but I will tell the court, based on my memory, it's as follows. Niall Brenner, because he ended up going into the house after, let me back up. Niall Brenner was acting very strangely after Susan died. He was acting strangely after Susan died because they had a very, he in essence did everything she asked. He didn't have the guts to tell her, get lost, I haven't made any money off you. He would have to go down to her house to swat flies. He couldn't get rid of her. When she died, his response was almost joyful to some degree because he was relieved of a burden that he could not undo on his own. He ended up making those comments to other individuals. In addition, it turned out that he had gone inside the house through a window after the police had been there. Now, as the court's aware, he did not do that on his own. In fact, Susie Harmon, Susan's close friend, went through the window first, told Niall about it, and he ended up going through. So, in addition, when he ended up going for an interview at LAPD, he ended up signing in, and he signed with block letters. Bill Lever has said that, you know what, I made the cardinal sin of a handwriting analyst. I looked at what was similar rather than what was different, and because he wrote in block letters, I ended up thinking, you know what, could it be him? So they then went and got exemplars, but before they did the handwriting comparison, they gave him a polygraph. As the court knows, there are many reasons why individuals fail polygraphs other than individuals being lying and being untruthful about what the nature of the polygraph's about. So
let me pause you. So in order for this really to implicate or to suggest a lack of a bias on the part of the officer would have had to encourage the handwriting expert to make that comparison and find that it be positive, right? I mean, that would be biased.
well, so you would have, so if you're talking by the bias, meaning the original detectives biased against trying to get a case on Niall Brenner?
Right, exactly.
Yes, and in fact, what we had and there's been no evidence presented whatsoever, the officer, the detective, has a motivation, Your Honor, not knowing anybody. He wants to find who the true killer is. So he went with what they told him. There's been no evidence whatsoever that he in any way interfered. They've been interviewed. They've given statements. There's been nothing that has said, you know what, we gave this opinion because of pressure. They were very clear. Bill Lever says, I screwed up. I made a cardinal mistake.
So it seems to me that they developed, it's almost as if the technique is to be biased against a person, to test that bias. Right. In other words, the bias is a hypothesis that you test, that then when falsified by proof that evidence that he could not have committed the crime, then they becomes quote unquote biased against Mr. Durst, and they continue to investigate him, yet it's never been falsified, right? And hence the prosecution.
You know, I'm going to tell you, I did not understand where the court was going.
All right, I'm just trying to work with you here and trying to understand whether there's some basis for admitting this, even if there's a concession that he could not possibly have done it.
Your Honor, can I add something?
Yeah.
As to the court's point or question earlier to Mr. Lewin as to whether somehow this would be supportive of some grand conspiracy amongst law enforcement, and I understand it's a hypothetical, but I think it's an important distinction to make. And are we talking about a grand conspiracy amongst LAPD? Are we talking about a grand conspiracy amongst LAPD and NYPD? Are we talking about a grand conspiracy amongst LAPD, NYPD, and the New York State Police?
I think the FBI is part of it too.
The FBI? I can go on.
Galveston.
Then we add in. Is this also? May I finish, please?
I'm sorry.
Are we calling him as a witness?
No, what I don't really understand, Your Honor, there's selective accusations. 1 minute, Detective Struck is no good when they want him to be no good. Galveston screwed up the case when they want him to.
Okay, yes.
Go.
Okay. I must have been making some headway. So then we get to Dreyke and Smerling, hit the ground running. Is this grand conspiracy somehow extend to them? And I think it's important for the court to consider and to understand.
Conspirators cooperate.
True, but they didn't know him at the time. The detectives on this case weren't even assigned, weren't even involved. Were you guys in RHD back then? No, weren't even in RHD, the Rami Hofstad division back then. They're the ones dealing with drug and smuggling. They're the ones gathering evidence now. They're the ones who have marshaled much of the circumstances which we're going to be presenting to this jury. And I think if the court does find some remote or probative value to whatever conspiracy the defense is alleging, I think it would be substantially outweighed by any possibility of confusion of the issues, undue influence, etc.
I think the only way it comes in, Mr. Chesnoff, is there may be, like I was suggesting before, there may be answers to questions which are legitimately posed that you may link together in a theory such as what you have described. But in order for me to admit this evidence, you have a heavy burden, and you would need to make a motion in advance of trial why that ought to come in. And I'm not satisfied by what I've heard so far, but I'm not going to foreclose you entirely. I understand that there could possibly be some, but as Mr. Bellion has described, the opportunity seems quite remote.
Well,
unless you paint with a broad brush and say, everybody, that side of the room is biased against me.
I will attempt to compose potential cross-examination in order to fulfill our responsibility, because the way we look at it, if a murder that he got acquitted of can come into court, the mistakes made by the police should come into court too, Your Honor.
Okay, but all right, but I mean, the people actually made quite a showing of a substantial similarity as to each aspect of that evidence. So it's not one for them, one for you. I mean, it just doesn't work that way. However, on that note, as far as Professor Denbo, I don't see why he shouldn't testify. Now, given the limitation that I described, for instance, that for him to testify, certain states don't allow it. I don't care. That's no good. But as far as criticizing the science and supporting the idea that one cannot reliably identify or compare.
That's what we plan on calling him for.
Now I have the floor, not you.
Your Honor.
Please be seated, Mr. Lewin. I'm making my ruling. That is my ruling. Okay. Yes, you wish to be heard.
Yes, Your Honor.
Yes.
Two issues.
Yes.
Can the defense be admonished once and for all? They cannot bring up offers to take polygraph or polygraph results. I want to make sure it's on the record, Your Honor, because it's misconduct. I put it in 2 different motions now. The court's told them about it before, yet here they are today talking about polygraph results.
All right, Mr. Lewin, you heard my ruling. They're not going to be mentioning evidence that is not admissible.
Okay.
They can't do it in the opening statement. They can't do it, I'm foreclosing them. But subject to your motion.
Thank
you
you.
can make a pretrial motion.
All we're doing, Your Honor, was trying to provide the totality of the circumstances to understand the police procedures that were utilized in the course of this investigation. We know our responsibilities in terms of saying somebody failed a polygraph.
No, can't mention a polygraph, period. They're not
I'm
allowed.
just mulling over this totality of the circumstances part. I'm not sure that's a good idea either.
The second issue, Your Honor, that comes up related to this is the defense at different times in this case has made third-party culpability arguments that now Brenner's the killer, that the mob killed her, that Eve Askin killed her, that potentially Sarah Kaufman or Paul Kaufman killed her. So we have not received any third-party culpability motion from them at all. And Your Honor, as the court knows, and this is my concern, if they intend on offering third-party culpability evidence, either through cross-examination or through their own witnesses, it needs to be ruled upon pre-trial. Now, the court gave a deadline of originally May 24th for these motions, and I brought that up. We're now almost in November, and they haven't filed. Their expert witnesses are due November 15th. We are still supposed to be litigating the parts of the statement, the confession Mr. Durst made to myself and detective.
You said that before, Your Honor.
That they want out. None of these
we have
things.
an agreement
Let me
given to
finish.
you by the 12th of November. Yeah, you can insist on repeating it.
So Your Honor, so what I'm saying,
This is our report.
I'm not going to. Your Honor, I didn't interrupt them when they spoke. So,
I think you guys can do it.
so, Your Honor, very quickly and briefly, November 15th is the deadline for them to give their expert witnesses. We are way past the deadline for them to submit their motions. If they are planning on filing any third-party culpability motion, Your Honor, it needs to be filed by November 15th. In addition, and as important, we need to set a date to litigate the statement, the parts of the statement they are objecting to.
Let's do the 15th.
The 15th?
15th.
Your Honor, that only gives us, it's November. Oh, November, the 14th of November, Your Honor?
So, the January date on the 15th, we discussed, was the possibility of delaying.
November 14th for the.
Hold on. Well, giving those your traditional users for returning your. I'm trying to get trial another MRSA on the 18th.
So you're saying November 12th, Your Honor, for the motion?
Well, I want to check. I don't know if it's
The motions in limine that we filed,
Well, I wanted to, we talked about when you were turning over expert reports on the 15th, but that's not a good day for this. Of course, here, anything such as the statement, and you wanted more time for those statements.
Your Honor, what I understood was we would submit a written analysis of finished, and my understanding was you would review it and make a ruling as to what was going to come in and what was not going to come in. Do you need a hearing?
We need a hearing. We have a right to be heard on whatever you are asking for, the judge is going to decide. We want to litigate like anything else.
We agreed that we would get it filed by November 12th. That was what Mr. Yeoman and I agreed.
That is true. I told him, so if it's filed by November 12th, we'll be ready to litigate it November 14th.
I'm worried,
On the 14th, that'll be fine. Well, yeah, I guess I'll argue that.
And Your Honor, so on that date, then, they'll also have the third-party culpability in essence in the limiting motions they haven't filed regarding third-party culpability or this issue ought to be filed before that date in time for us to respond.
We're finding something, I thought we were finding something on the 15th of January.
What's that, Your Honor?
unlikely to grant that the motion to admit that.
But no, but Your Honor, but I can't, Your Honor, I agree, but I can't be presumptuous enough to say, don't worry about filing it, right by trial, Judge probably won't grant it anyway. I don't think he will, because they don't have the evidence to back it up, but again, they were supposed to file this stuff months and months ago. I bother them frequently with emails, phone calls, etc. They don't do it. So it needs to be.
I appreciate the fact that we do a lot of this pre-trial. Sometimes this goes done with it for jury selection. Typically, what I'll do, I'll try to one day for these motions before long murder trial, but of course this is a long murder trial. So I appreciate doing these in advance. I don't think it's.
The third party becomes important for us to litigate, Your Honor, because let's assume under some crazy scenario, which I can't come up with, if the court allows third party culpability evidence on these issues. That means we're going to end up having to call witnesses you would not call and do work on the call.
All right, my understanding is on November 14th, we're going to have a hearing on the filing that we're going to make before November 12th. on the questions of Mr. Lewin's interview of Mr. Durst, correct, Your Honor? And that would be what would be heard on the 14th.
Yes, now, as far as let's talk about, let's talk about the trial date. So, I was very pleased in the chamber today that we had, I think we're approaching an agreement on some stipulations, and we've also discussed a jury selection procedure that I believe will reduce the length of the trial by 1 month. That's why I am comfortable in agreeing with the defense request to the 10th.
I think you said the 11th of February. I thought that's what you said, that's what I heard.
Right.
Yeah, I believe the 10th is the court holiday, I think. Is that right? And that's what President's Day is.
I think 1 day rest before,
10th is a Monday.
I know, but it's,
I'm not sure if that is something.
It's not. It's not President.
no, I believe it's not.
President's Day is on the 17th.
Did you want to do the 10th thing, Ron?
Oh, we celebrate the end of it right here. Well, all traditional.
So what day would you like to do at the end of the stuff?
Right. And Mr. Durst's practice, we always asked February 11th, and we certainly agreed on an earlier date. We're getting right to trial by January the 13th, to that agreement said to 11th February. The 11th.
So we passed the trial for February 11th.
Is that okay with you? Yes.
Agreed? Yeah.
Yes.
Agreed then.
Thank you.
No further continuing.
Your Honor, and can the court just, I know we discussed in chambers, but
Yes.
can we just put on the record that it's the court's position that in essence, as long as there's one lawyer available for each side, we are doing this trial February 11th. What's that, Your Honor?
I don't take positions, I make orders.
Well, Your Honor, well, you order that there is,
As long as it's just me and
I
John.
rule.
thank you.
That's right. No lawyer. Old school, like I used to do it.
That's right.
One lawyer, what's his second chair?
Exactly.
All right.
Your Honor, sorry to interrupt. I think we might have ordered Mr. Oliver back in January. If so, if we do it for the February date?
You want to give him a break?
When the court had said, I think we said the January date because we're still going to be here on the January date, correct, Your Honor? So we're still going to be 113, and then the court said if I'm satisfied, then the court gave me permission to put him on call.
That's right.
Thank you, Your Honor.
Okay, now, do you want to talk about your motion to unseal that document?
Yes, please,
Okay, I'm gonna grant it, but let's make it subject to a protective order, and I'm gonna order you to, I'll bind the people with that protective order and the staff.
And so we will get a copy from you, from Mr. Lord?
If you are asking me to, I'll have copies of the court.
Okay.
Your Honor, then the final thing is, are we able, because we have the Steinman is still here, are we able to go back into the chambers outside of the, regarding the issue of, some issues I wanted to point out to the court very briefly on, it can be off the record, on cross-examination, privilege, invocation in front of the jury with the client, because she's here, I want to make sure the court is aware of this information in advance.
Yeah, I think we should discuss it.
Thank you, Your
Your
Honor.
Honor, I would like to say, this is the person who should be scheduled to leave today is Ed. For example, I'm not always familiar with where the Discovery Is
my suggestion is
I'm not making any rulings or.
Want to ask me?
we listen, and then I'm sure that's it, we can put it in the motion and limit it, and then
Well, that's a good thing with an email. Reply from the handwriting.
Why not stop the date for that?
Just the 10th.
This will be helpful, you know, we're having this chamber discussion. Will be helpful.
can we come back?
No, not until I adjourn, right? We're adjourned? We're coming in, so as far as your other motion, 256, that's.
Right, because we're going to do it on number, 356, Your Honor, yes, the point of the 356 motion is to make sure that the court, that was really more for the defense. I assume, Your Honor, did the court agree with the legal? Thank you, Your Honor.
All right, and then,
Wait, Your Honor, that means so motion granting with respect to 356.
we're gonna do a hearing, you want to do a hearing on the motion?
Well, I mean, there's not much to, it is what it is. 356.
The motion is, I don't think it's going to be worded, So on the record, we are not adjourned yet. Quiet, please, for some moment. I'm
I have an announcement.
What's the actual,
14th, Your Honor.
November. That'll be in November.
Thank you, Your Honor.
Department 81's adjourned.
Hey, Bob.
Yeah, I got it right here. Yeah, I'll turn it down next one. No, I was good to see you.
John, can you fire this up? I really do have to go to the hospital.
Make this quick, Dave.
I'm